The sky is not falling.
The sky is falling! The sky is falling!
Despite what other YouTubers might be talking about, I'm going to tell you real quickly in just a couple minutes what's going on and what's not going on with the Veterans Benefits Improvement Act of 2024 and publicly facing DBQs. Hey, Andy Gross, Guidon Law, formerly known as Law Office of Andrew P. Gross. And if you've been in the YouTube space looking for veterans benefits videos, you've probably seen a number of content creators and folks holding themselves out to be experts talking about the Veterans Benefits Improvement Act of 2024 and, wait for it, the sky is falling, the removal of publicly facing DBQs from the VA's website. Oh my gosh.
The sky is falling! Are you crazy?
Everyone take a deep breath. Everyone take a deep breath. Let's talk about what the law actually requires. So I'm going to read from the summary right here of the law. First, the Act updates procedures related to the publishing of VA disability benefits questionnaire forms. Specifically, the VA does not have to publish certain forms if it determines the form could not reasonably be completed to a clinically acceptable standard by someone who is not an employee or contractor of the VA. Basically, what this is saying is the VA doesn't have to publish forms if it doesn't believe that they are of use or could be filled out to a clinically acceptable standard by someone who is not an employee or contractor of the VA. Now first, and I'm going to get cynical for a moment here, I'd say the contractors aren't filling them out to a clinically acceptable standard. And you don't have to believe me, you just look at Board of Veterans Appeals decisions that remand for adequate exams, of which there are literally thousands. I think it's kind of funny that this law is going to allow the VA to make the determination that nobody else can fill out these disability benefits questionnaires to a clinically acceptable standard except contractors. But meanwhile, the VA is doing absolutely nothing, or feels like they're doing absolutely nothing, to actually hold their contractors accountable to actually do the forms correctly. But I digress. Let me just step off my soapbox there for a moment. Now, before I go any further, let's talk about DBQs and what they're used for. Now, disability benefits questionnaires come in two flavors. One is the medical opinion, and one is the more what we think of as a DBQ, which outlines the severity of the condition itself. So it's a two-part system. Now, for presumptive issues, you don't really need a medical opinion. You just need to catalog the symptoms and the severity thereof, and also what conditions are related to whatever is presumptive. For instance, if it's a diabetes claim, there might be peripheral neuropathy, hypertension, diabetic wounds, all sorts of separate DBQs for this one condition. Likewise with TBI, because a TBI can also mean mental health problems, sensory problems, motor control problems, headaches, obviously. These DBQs allow the VA to catalog, if done properly, the various problems that a person may have for the condition. The second part is the medical opinion. And the medical opinion disability benefits questionnaire is filled out by the C&P examiner to determine whether or not something is or has a nexus to service. So what they have to do is they have to review these service records to the degree that they're available, the service treatment records, whatever current analysis, usually the disability benefits questionnaire that determined the severity of the symptom, and determine if the current condition is related to service. Because if you remember, VA disability is just that there's something wrong with you now, and that has a medical nexus to something in service. Any doctor with the requisite knowledge who's done the review of your records and your conditions can render a medical opinion, and this medical opinion, of course, has to be suitable for rating purposes. It needs to apply the appropriate standard, which is it is as likely as it is not, and it has to have an adequate foundation. It has to go through the records and say, yeah, based on the data, based on what happened in service, based on the current condition, it's as likely as it is not related to service, whatever the condition may be. The actual DBQs, though, related to the severity of the condition, well, that can be documented in many different ways, but the DBQ, especially the public-facing DBQ, does a very nice and concise way of doing that, because it lists out all the range of motion tests. It lists out the questionnaires the questions that come right out of the CFR. In a way, it's convenient. Let's go back to this though. This doesn't mean that the VA is going to pull all the public DBQs off the website tomorrow, or the next day, or the day after. This law does not tell them to do that. It authorizes the VA secretary to do that, but doesn't tell them to do that, and doesn't tell them to remove all of them. But even if they did get removed, that's not a huge problem. It's not the end of the world, because ultimately, you can still document your symptoms or have your doctor document your symptoms along the way to substantiate all the same information that's on a DBQ. The problem is, and this is mechanical, inside the VA, is that the VA probably won't review those records closely. They just don't. It's any current or former or recently departed veteran service representative or rating veteran service representative can tell you that they're on a time crunch, and they love taking these DBQs and looking at the symptoms and copying it directly into the rating without having to do a deep dive and find, well, what was the range of motion on the guy's neck from the guy's 200 pages of physical therapy records. So we can really get around this, though, by figuring out what the rating criteria are for the various conditions, and then asking your doctor to document those. And if the VA doesn't get it right in the rating because they ignored what your doctor said, well, then you go through the appeals process, and that's what we help you with. So with that in mind, again, the sky is not falling, and even if publicly facing DBQs disappeared, it's not the end of the world. DBQs are not the magic pill that gets you a service-connected disability. It is a tool used by the VA to concisely measure the severity and service connection of a particular disability, something that you can do without one as well. You just got to do a little bit more work on it. If someone's doing a 20-minute video on publicly facing DBQs talking about what this new law is, and they have a monetized channel, ask yourself, are they putting out more heat or more light on the subject? This is not reason to panic. This is not reason to get worried. Publicly facing DBQs, even if they did disappear, which I don't think they will, you can call me on that later on if I'm wrong. It's not a reason to panic. I hope that helped. If you have a denied disability or you're underrated, give us a call. Let us see what we can do to help you out. And until next time, take care.